Head to Knoxville, don't be late. Baker's Live, it's gonna be great. June 5th and 6th, mark your date at Dollywood, we'll celebrate. Meet Baker and more cool friends. Live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. Rides, fun, and meet and greet. Baker and pals, the crew's so sweet. Get ready for laughs, cheers, and thrills. Knoxville's the place, it's giving chills. Meet Baker and more cool friends. Live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. June 5th and 6th, don't miss the fun. Meet Baker and friends, it's second to none. Baker and friends, it's second to
Good morning, good evening, good afternoon, and I'm early, Brandon. Just because you peed the bed and was up early, I'm still on time. And thank you, Iris, for reminding people to hit the likey poo. Do it. And Iris is happy that I was out shopping in my local town today, and 2 different stores was carrying tagine. So she might come back to Denmark. Hey, Tim. And Lolita smiles. Jemima. They are on verdict watch in the trial, but they had closing arguments yesterday that we didn't cover. So I am shooting 2 birds with 1 stone and doing it today. Hey, Anime. And Fedorowski. And Dave. And Crispy Bacon, and Carly Kramer, JBH, Teresa, Sui. How you doing okay today? Yesterday, Hanky Panky made me so angry, so I'll just say it as it is. Hanky Panky is a vet and needs a good vetting, in your opinion. I am actually good. I did my recap video this morning. When I went to bed yesterday, I thought, I'm just going to be screaming for 15 minutes. But then I was getting all those clips from around the twits, and I was kind of like in a state of sin, just, this ain't going to change. This is just going to get worse. So if I scream now, what am I going to do the next time? Go bald like Lally? Because the amount of effery we have seen by this pro sector is absurd. It's the amount of disrespect to his colleagues, the total disregard of any truth is just so infuriating that if it gets to you now, how bad is it going to be when he's going to bring in an expert that says because of the lunar equinox she did it. I'm thinking we're going to have a tarot reading in court that he claims is scientifically proven to be right, that magically turns over the tower, the car, and the maiden, which is a clear indication that Karen Reed did it. I'm thinking we are going to hear testimony from a magic 8-ball at some point, even though Jemima don't want to see it in court. He's going to bring in a Ouija board and talk to John O'Keefe himself. I'm thinking puppets will testify, and everything will just be met with a, I'll allow it. Mr. Jackson, your objection has been noted. I'll allow it. So, I'm kind of just, I went, hit some weights, did nothing connected to the Karen Reed case, and then I just settled in despair, because this is going to be the worst case I have covered in my 2.5 years, because nothing will be factual. Everything will be lies, innuendos. Bringing in the Aruba chicks by Lally was probably some of the stupidest things I've ever seen. And I watched the Zach Anderson case. But this is going to be worse. He's going to find someone who went to kindergarten with her, where she once stole a raisin pack from them, and going to use that as a sign of guilt. Yesterday, he claimed that a cut video from that investigation discovery special is a sign of guilt. It's cut together. We don't know what was right before. We don't know what's right after. They cut it together for maximum shock value. But he's going to use it as conscience of guilt. He put her defense team on the witness list. I don't know. It's just going to be stupid. Are we going to hear from that girl that John O'Keefe held hands with 45 years ago, how she actually have spoken to him since, when she's sitting there and claiming that he was the greatest love of her life? Well, he didn't call you when the COVID hit. He called Karen Reed. So just because you're a crazy stalker, he didn't feel the same way. We're going to have Natalie the German to come in and say, yeah, they were talking to each other. They interviewed her and didn't choose to bring her in the first trial. Now they're going to bring her to prove a conspiracy that a grand jury has said doesn't exist. Yeah. It's just going to be ridiculous, and if I let it get to me now, when the court starts, I'm just going to have a stroke. So, nah, it'll be fine. It's going to be fine. Oh, yeah. What is your shirt size? We're having something made for you for Dollywood. I'm an American double XL. So it depends on what brand you're using. If it's a shirt saying, I will bang for a green card, it's not true. I'll bang for free. No, I won't. You don't shit where you eat, and you don't bang where you make money. Thank you so much, Carly. I'm wearing it right now. Thank you, Dave. Today's t-shirt, given by Dave. Fits. Thank you so much. Yeah, this is the one from you. Reasonably prudent person. But we're not talking about Karen Reed today, because then I'll lose my mind, start yelling again, and start drinking. And nobody wants that except Brandon. So let's listen to the closing arguments in the Jason Levesque case, the plow pew pew case, and find out what the closing arguments will be. Oh, hey, Helen from Holland. You're nice when you lie.
Good morning, ladies and gentlemen. Nice to see you all back. So as I explained to you yesterday, we are now at the portion of the proceedings where counsel for each side gives you their closing arguments. And so we will start with Attorney Sisti when you're ready.
Thank you, Your Honor.
It worked. We beat Portugal 1-0, so F you, Ronaldo.
Good morning, folks. I think I want to start by telling you
Good luck, gents.
a little bit about closing arguments. But before I do that, I want to thank you, and Jason wants to thank you. It's a tough case to sit through. Tough evidence. The videos are tough. They're critical, but they're tough. You saw a pretty gory video, a scene video where
What? Come on. Why the hell? No, I closed the wrong one. I was supposed to bring this one up. What's wrong with this setup? You have your three center backs that's gonna anchor your defense. Then you have your wing backs going back and forth, so you can overload on attack, but still come back and help defense and overload there. You have Eriksson, who will be the midfielder going forward. Nørgaard, probably the one who will be the tie-in between the midfield and the defense. Hjulmand, the guy who will go behind Eriksson and be the transition player. And you have Lindstrom and Beard on top. Look, Iris, number 7, who is Dorgu, is not the guy who, because it was also a woman, but he plays for Manchester United. So does Højlund. So does Eriksson. And down here where you can't see it, there's a guy called Froholt. It's not the same guy who plays in the NFL, if anyone was wondering. But it's a totally cromulent system, 3-5-2. Yeah, that's because a 4-3-3 is kind of become the modern standard. But 3-5-2 it's more a defensive system if you don't have the wingers. If you play with a team like Portugal, you'll probably play a 4-3-3, because then you'll have center halves, and then you wouldn't have the middle guy with Vestergaard, and you will have one striker, you would have the wingers out here. You would have one offensive, one defensive, and one midfielder. Number 7 was on the bench. On the national football team, you're given a number. You're not playing the position. You're given the number, and then wherever you are, if you're going on the bench or if you're going on the field, it doesn't matter. You'll still keep the same number as long as you. Well, most people will play as long as they are on the national team. Eriksson, I think, changed his. I used to be number 3. Then I was number 13. and number 1 when I was a goalie. But yeah. So 4-3-3 has kind of become the modern version where everyone before played 4-2-2, but 3-5-2 is more of a transition defense style. What's baking fuckers? What? Who? I don't... What? It's... It's too early to day drink, Brandon. Well, an aggressive 4-4-2 is not as aggressive as a 4-3-3 because 4-3-3 is to overload the other. 4-3-3 is more all around, and a 3-5-2 is more defensive.
There's some medical work done on the alleged victim on the 4th of April, 2024. That's tough to take. I mean, we all know that. But we do hope that you hold to your oath and that you objectively look at this evidence, okay? I mean, it's really important. I don't know how to stress it. I don't get to speak to you again after this. I mean, I'm handing Jason off to you this morning. That's what I'm doing. He's totally out of my control. Okay. We trust you.
Don't spend so long talking about how thankful you are for the jury. Talk about why your client isn't guilty.
Okay. We trusted you when you all said you can give him a fair trial.
I believe in New Hampshire, the defense always goes first. Some states have it that way, which I actually think is better than the state defense state.
He trusts you. And, it's quite a process. I'm sure that, you look back at this process years from now and say it's pretty impactful. I'll tell you something else. You can kind of exhale a little bit because there's a rule. I mean, we can't go on forever. There's a rule in this state where I can only use up as much as an hour. Prosecution can only use up as much as an hour. Then the court instructs you, and it's all yours. Just like the view that you took control of. That was your view. This is going to be your case. You're going to own this case. This one's yours. You take as much time as you need to deliberate when you get it, and you go over it carefully. Okay? Review all the evidence, and come to a reasoned conclusion. All I'm going to try to do during my 1 hour is to try to guide you as to where we're going, okay, what we're doing. And from the very beginning of this case, when I first had the opportunity to discuss this case at all with you, it hinges on self-defense. And let's just cut right to it. You know it, okay? You know it, and you feel it in your bones now. And you've seen it on video. Okay, but I want to start filling in the blanks a little bit for you and giving you an overview on what this thing's all about. Because you're going to get instructions, and they are quite helpful, and there'll be a handout that I'm actually going to refer to a little bit during the closing. But you're going to have it, and you'll be able to go over it and use it as long as you want. And what the jury instructions are, quite frankly, they're like a guidepost. They're the law. It's like a roadmap. And you plug in the facts, and you use this law, and you're going to come to the right decision. Right? That's the whole idea here. Now let's talk about what went down here, okay? And really the case starts before April 4th. It actually starts a few months before April. And a few months before April 4th, none other than Kyle Violette, for some insane, crazed reason, approaches Jason while Jason's minding his own business. This is going to be a repeating theme, by the way. While he's minding his own business, doing work on his house, an enraged, delusional Kyle Violette approaches him and does what? Threatens him for no reason at all. For some paranoid, made-up reason. And the paranoid, made-up reason back in October of 2023 was that Jason was informing on him to the police, which has no basis in reality.
Excuse me, can someone help us? Yeah, someone call 911.
We're going to skip this part. The defendant's dad had a medical emergency, so we're going to skip that part.
Very good. You were closing. Very good. To the hospital.
The defendant's dad had a medical emergency during closing arguments. But we're going to get an update here.
No, I had training. That's what I did. I didn't expect it.
Okay. Are you ready to go on the record and talk about what we're going to do, or do you need a few more minutes? You're talking about your client. Okay. Well, in the meantime, my plan was to simply tell the jury. I was going to tell the jury that the person in the audience who had the medical emergency is doing okay. I want to reassure them that he didn't pass away or something, because I think that would be unfortunate for them to think about. I don't want them thinking that. So I'm going to tell the members of the jury.
Did he say he felt that?
To simply tell the jury. I was going to tell the jury that the person in the audience who had the medical emergency is doing okay. I want to reassure them that he didn't pass away or something, because I think that would be unfortunate for them to think about. I don't want them thinking that. So I'm going to tell the members of the jury that the gentleman who had the medical emergency has been transported to the hospital and appears to be doing well. And I'm going to tell the members of the jury that obviously that shouldn't impact what they're doing in this case in any way. And then we'll go on with closing arguments, unless either party wants further instruction beyond that, which I can't imagine what further instruction we would give the jury beyond that. All right. Very good. And take your time. And also, Attorney Sisti, I'll let you think about whether you want to restart your closing argument, given how early you were in it. If you felt like it was better to just restart the whole thing, you're welcome.
I think they must have, because it's 20 minutes later, so he probably heard from the hospital that he's admitted and he's not dead.
Welcome to do that, or we can have you pick up where you took off. All right? Very good. So what we'll do then is just take a few more minutes, because it sounds ready.
So finally, something interesting.
Incident during the... Okay. Thank you for your patience, ladies and gentlemen. These things sometimes happen during trials. As my staff informed you, the gentleman who had the medical incident during the proceedings is doing well and has been seen by medical staff. And so at this point, we're going to reconvene. Obviously, what happened in the courtroom has, as you can imagine, has no bearing on your decision in this case, one way or the other. So I ask that you not give any further thought or consideration in terms of your role as jurors in this case. And so we're going to continue with Attorney Sisti's closing argument. Attorney Sisti, you have your words.
Thank you. And thanks for hanging in there. I was telling these men, you got to see me do what I used to do a long time ago. He's okay. All right. Okay, let's start this again. I'm not going to go over this. The very, very basic principles of why we're all here. And basically, why we're all here is to give Jason a fair trial and to follow the principles of law as they were outlined to you by the judge. And we'll go right back to the beginning. It was proof beyond a reasonable doubt, burden of proof, presumption of innocence, and then, folks, the additional thing in this case was self-defense. And you all got a grasp of what that was. And you got to see some of it during the course of the trial, and now I'm going to try to explain where we are with this thing. Okay? Like I said, this is an interesting case. It's a self-defense case. There's no question about it. And there's some very graphic material in here, very graphic medical material. You saw that video, and you heard about what was taking place. They're heroic medical procedures, I can assure you, that kept Kyle alive. And he was very lucky to have a combat-trained individual on scene at that point in time. That's all I can tell you. And he's alive. So the gory film that you saw, frankly, is not at issue. The injuries were very significant. There's no question. Gunshot wounds themselves are very significant. These were very significant. But this is a rare incident, folks, where you get to see somebody, in this case, Kyle, Violette himself, the centerpiece of the prosecution's case, in a situation where not only was he threatening on April 5th, something that he had done before with Jason. And I'll go back to that. The October incident, for no reason at all. The threat to his life, the threat to his family's life, right in front of his own home, for no reason at all. And we almost have an instant replay of that. But this time it's even more bizarre, because this time the claim is that he's plowing snow into his driveway or something to that effect. The beautiful thing in this case is that you have some film that you can actually look at.
I don't think the victim has ever been in the courtroom.
And if you look at it, Jason is actually being extremely careful in the plowing, not to interfere 1 inch into Violette's driveway. And he's minding his own business. Jason had gotten up on April 3rd at about 8 o'clock. By the time you see him plowing, all right, he's already into about his 38th hour of being awake, of working, not just being awake, but working. Now let me suggest something. When you go back into the jury deliberation room, you may want to do this. You may want to take a poll of everybody back there and ask who back there has been up for 38 to 41 hours in a row ever in their life.
But it's not a defense that he willfully deprived himself of sleep. It's a stupid argument. He could just have said, no, I'm not going to go plow the snow. He was, I thought, the first day or so. I can't remember. We haven't seen him. I know we talked about him being there for the bail hearing we had in July. I think it was July. Yeah. And thank you, Aussie Overlord, for the raid. And welcome, Aussie Overlorders, Raiders, Kangaroo, Pouch people. We are watching closing arguments in a case where a man claims he had to self-defend himself with 5 bullets into the back of his neighbor. We just had a medical emergency, so it's all fresh and new. Well, thank you. Yes, this isn't a dead case. This is attempted unaliving. It's not. He's not dead. He got 1 in the collarbone, 1 in the jaw, 1 in the stomach, 2 in the buttocks, and I think 1 in the chest below the heart. No, 1 in the scrotum, sorry. 2 in the buttocks, 1 in the scrotum. 1 in the collarbone, 1 in the jaw, and 1 in the lower chest or stomach area. It's not a rule it must be a guy called Jason.
You may want to say, if somebody does raise their hand, how did it feel? Did you feel with it? Were you working during?
Also, my big problem in this case is he was in his face, then he walked away, and he says he pews him when he turns his head, gets him in the head, he falls over, then he walks up to him and gives him 5 more just to make sure, and he wasn't even sure because he survived. So I have a hard time, but again, they did 4 or 5 hours of verdict watch yesterday, and they are on verdict watch again today. So it's not an easy case. I watched the guy in the nightclub who got sucker punched, which I thought was which was clear self-defense, and he got found guilty in, I believe, 2.5 hours. So kind of weird. Could be he had PTSD and doesn't want to see him, but it's just, it would work really well with the jury.
In that particular period of time? Were you in a combat situation? Just what was it? Were you in the comfort of your dorm room or your home? You know, get the context. But I assure you, if there is somebody that was up that long. They will tell you that they were worth pretty much nothing mentally, pretty much nothing physically at that point in time. And you can all relate to that. I mean, there's nights where you just want to go to bed, even though you've been up for only 15 hours. This is more than twice that length of time. So when Jason is confronted by Kyle Violette on the evening of April 4th, 2024, we know for sure from the video that Violette initiated the contact, and he literally, physically assaulted Jason. He placed his face intentionally on Jason's face. Now, why would somebody do that? And again, what would a reasonable person believe if somebody did that to them out of nowhere? Well, Violette did it to threaten him. The physical act alone was a threat. I mean, imagine that. Imagine somebody coming up to you out of nowhere and sticking their face right onto your face. But it's not just sticking his face on your face. It's threat.
Funny story, when I was in Knoxville last year, that's exactly what Valhalla did. He stuck his face right on my face. Not on the chin area, though. It was more sub-nose above chin area. And he said, "Do you like it when it scratches the beard?"
Threatening him at the same time. And it's threatening him at night while he's minding his own business at his home
yesterday
with his daughter in his truck. That's the context. That's the very context.
No, screaming and yelling, no, 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 doesn't mean I initiated.
Of when this starts. That's the alpha. That's the beginning. Kyle Violette really is the alpha and the omega of this kid. He started this. You know, you wouldn't be sitting here at all. Think about this. You wouldn't be sitting here at all, but for...
Sorry, Jemima, have you seen the last request from Special Pro Sector Brennan? Special Pro Sector Hank Brennan, in support of Commonwealth's motion to compel non-privileged communication stored in defendant's cell phone data. Commonwealth's motion to compel communications between the defendant and attorney Yannetti stored within defendant's cell phone data. So now Brennan wants her communication with her lawyer. They've had that phone for I don't know how long. No, I think you said I didn't want it. I wouldn't have done it or something like that. These are the new filings today. Remember when he said yesterday, deadline for motions has been passed, Your Honor. I hate to say he's crazy, but he is. That's a new... Well, I said it in the beginning. If I felt like yesterday was the worst we saw, I would just get disappointed. So I don't believe we have hit the lowest of the low yet. If that's not denied. Yeah. Hey, 80s. They mean like if she forwarded a text, no, 618 says Commonwealth's motion to compel communication between the defendant and attorney Yannetti stored within the defendant's cell phone data. So that's all communication between her and her lawyer. Is he going to do the, I don't trust the taint team, so I'm going to look through it just to make sure it's okay when they look to it? Brandon, do you know of this little place called the Canton Triangle, where rules and science doesn't apply? Yeah, it should get tossed instantly, but it's Beverage who has to make the assumption. So read the one below it. Yeah, but that's all non-privileged communication. The first motion is all communication. That's not a distinction. So if she gives them 619 is just an affidavit. 618 is compelled communication. So there's not non-privileged in that sentence. Unsolved productions. Oh, that's the investigation discovery. He's such an asshole. Oh, so they just want whatever they can get. Fishing expedition. No. He's very specific, going after specific elements of specific things, but he needs all of that data so he just can. That's what he said to Aiden's in the courtroom yesterday with Aiden, that he was looking for something specific, and the judge said, "What is it?" "Well, I can tell you when I have it." That sounds like a fishing expedition. No. I know it when I see it. That's not how the rule is. You have to tell us exactly. But go and read that text where it says that Aiden has to turn over everything he has about harassing the people who killed John O'Keefe or know who did it. Because that's actually what it says in the sub note. This is Lana Del Turtle. She's normally pretty good. But 618, 619, 620, 621, because they also want all the behind-the-scenes stuff from Discovery. Isn't that one of the main reasons we dumped all that Danish tea into the harbor? Well, you should come back to us, because this shit would never go down in our court system. Because I'm there. And I'm a straight shooter. Well, except with some mornings. Well, we don't have closed-door Danish proceedings. I wish you were I think you wish you were Danish right now when you see how bad Canton is.
Kyle, Violette.
Good morning, Nick.
Why did everything go down like that? What was that scramble all about? It was all about Kyle, Violette. He placed himself in a position intentionally to threaten Jason. To threaten Jason with death. There was nothing conditional about sticking his face on Jason's face. And there was nothing conditional about threatening. And you'll see that it happens more than once. When you run that video, you take a look at how many contacts he had. I mean, what was he trying to prove? What in the name of God was going through his head? Other than to try to scare hell out of Jason Levesque. And to relive that same threat that he had with him months before. And again, it was for no reason whatsoever. None. Zero. So we know that he initiated the contact. We know that he stuck his face into Jason's face. We know that he made threats. He made multiple approaches. I'm going to ask you, I'm going to go through self-defense instruction in a second, but I'm going to ask you, do not abandon your common sense when you say it. When you looked at that, what did you see? Did you see some cool, calm guy coming out to say, please move some snow, please don't block my driveway? Or did you see an enraged, out of control, insane guy coming up on somebody minding his own business in the middle of the night? And that's the context that you have to take this case. And you're going to hear from the judge that you have to basically run it through the lens of what was going on that night. Not today, when we're all sitting in a courtroom, cool and calm, rolling it over in our heads, and going frame by frame, like Detective Dan did. Because that's not reality. The reality is that this whole interaction took about 11 seconds. This is quick stuff. Quick decision material with a man that was shocked that he was even going to run into Kyle Violette that night. There was no reason for it. Reason means something in this case. If you think for a second that Kyle was not threatened, that Jason was not threatened, then you got to think of it. Anybody would have been threatened in that situation. Anybody would have been concerned about protecting themselves. Anybody would have been concerned about protecting themselves when
I don't
somebody's
have foot
saying
fetishes.
that they're going to kill him. Kill the
Maybe you
family.
should call Rex.
Both.
He likes feet.
That's the context that we're dealing with. That's the case. That's the case. But frankly, it's more than that because Kyle, he wouldn't give up.
Verdict board started. They had around 5 hours yesterday.
If you look at the video, he walks away, and you'll see his arms all over the place. You know what's going on there. And you see Jason standing still, doing nothing. You've got one madman screaming at Jason Levesque, doing nothing. And then he starts back at him. And that happens a couple times. And the last time he comes back at him, he's screaming at him and he's telling him, you don't know me, you don't believe it? The threats keep coming. Threats keep coming. And I'm going to ask you something. Okay? How many times do you have to put up with that? Do you have to wait until somebody comes at you with something? You know, Jason Levesque didn't have the wonderful experience of what the deputies do in this courthouse when you enter through the front door. And that is check people out, see if they have any concealed weapons or metal or anything. You have no idea what he had. None. And you'll hear in the instruction that he doesn't have to even be threatened with a weapon. All this questioning about, did you see a weapon? Does he have a weapon? When you got there, did he have a weapon? Guess what? That's a mirage. That's a mirage. All Jason has to believe at the time is that somebody is out to kill him or cause serious bodily injury at that time. Not 5 hours later, not 2 hours later, not 2 minutes later, certainly not a year later, but at that time. What would a reasonable person believe at that time? After somebody who had threatened you months before for no reason, and then came out of a house and threatened you again for no reason, and threatened death to you, was coming at you. What would a reasonable person think? Think something good was going to happen? Think they were going to talk it out? He was violent.
Yeah, I feel
He was threatening.
I need some of that.
And he was out of control. That's what Kyle. That's what you were dealing with. That's what Jason was dealing with. And you know, you can put as much lipstick on a pig and earrings and bracelets and everything else that you want. But at the end, it's still a pig. Kyle Violette is no.
But it's going to be a beautiful pig if you do it. So I'm just saying. Unconfirmed rumors says Jason Levesque has a special shade of pig lipstick he likes.
Innocent human being. He bears the brunt of starting this thing, creating the situation, and the reaction from Jason. He bears the brunt of that. Nothing would have happened but for his behavior. Nothing. Now, in this case, you got to see a breakdown. And you heard testimony from Detective Dana. And remember, he got to go frame by frame. Remember what he was doing? It's not cool, but I mean, it was frame by frame. And something that, of course, Jason wasn't able to do. I mean, retrospective observations are interesting, all right? But that's not the test. But I'll tell you something very important when you do frame by frame and you listen moment by moment of what you can hear. It may be very, very telling as to what was going to happen. In fact, Angela LeChan was almost a prophet of what was going to happen that night. And she took the stand and she raised her right hand. She swore to tell the truth. And she made something up right here in front of you. Not after a traumatic event. not after over 40 hours of being up, not after 24 hours of work. She made something up to skew the case, to hoodwink you guys. Angela LaChance, Kyle Violette's significant other, made something up. I'm sitting there wondering, is the prosecution going to hug what she said and urge you to believe her during their closing argument? I think not. Because what she said, in coordination with the video, is basically the prediction of the future that took place just seconds later. What she said is impactful. It's her present sense impression of what's going on with Kyle Violette. That's her watching her significant other going down the driveway and confronting Jason. And Detective Danny captured it. In fact, at 10:11:22 on the 4th of April, 2024, Angela LaChance is heard saying, quote, "Yep, there he goes. I don't know, he's all the way out there. He better not do anything stupid." Now let's just stop. What do you think she's talking about at that point? It can only be one person. It can only be one person. And that's Kyle Violette. She's watching her significant other, and you'll see the video, coordinating with her speech, going across the driveway and approaching Jason. Just a few seconds later, Angela says, "You better not do anything fucking dumb." Who do you think she's talking about? Jason's just standing by the truck. She says, "Who is in Jason's face?" Kyle Violette. No, that's black and white. That's obvious. That's obvious. But she still had the gall to tell you, "No, I was actually talking about Jason." And that's absurd. That's ridiculous.
I didn't like the beginning of it, but I like that he, and we all thought that that woman was lying when she said, no, I was saying about the neighbor she never talked to. Hope he's not doing anything stupid.
Frankly, if you want to know the definition of a lie, that's a lie. That's a lie. That's an intent to deceive. That's an attempt to put a thumb on the scale, try to convince you guys of something that just wasn't happening. That's just something that's out there in outer space. That's Angela. That's Angela LaChance. What really happened that night, she could almost tell was going to happen. Somebody was going to do something stupid. You saw it. Now, in the self-defense case, there are many, many items you have to go over, and this instruction is going to help you.
I have had problems with YouTube glitching a couple of days. It cleared up yesterday, but I had a few days where it's glitching, so it might be YouTube glitching, yes.
And the judge is going to tell you that evidence is...
Everything on my end looks good. The only thing I have is I have a slight delay when I push buttons, and my camera is a little behind sometimes.
Been presented that the defendant has acted in self-defense. When there's some evidence of self-defense, the state must prove beyond a reasonable doubt that the defendant did not act in self-defense. I mean, that's a heavy, heavy burden, okay?
I actually think it's StreamYard, because when I hit this comment normally, it pops right up, but here it took a couple of seconds. Well, I'm spreading love and love-borne diseases.
You have to disprove self-defense beyond a reasonable doubt. If you have a reasonable doubt as to whether the defendant acted in self-defense, you must find the defendant not guilty. If you believe, in other words, that his reaction and his actions that night were centered around self-defense, then it's not guilty. It's clear. In deciding, this is critical now, you're going to hear it again, and you're going to have this instruction. In deciding whether the defendant acted in self-defense, you should consider all the circumstances surrounding the incident. All the circumstances surrounding the incident, which include the prior threat, all the work he did that day, his exhaustion, the fact that he was put upon by surprise, and that he was threatened. You should consider how the defendant acted under the circumstances as they were presented to him at the time, and not necessarily as they appear upon detached reflection. So you have to step back. You have to see how he would have been seeing things at that time. Okay? Not under a microscope, not after, clear, detached reflection, none of that. But at the time, these things happen quickly. And that's why this particular instruction is important. You should consider whether the defendant's belief that it was necessary to use deadly force was reasonable when he acted in the heat of passion. Not coolly and calmly, right? Not rolling it over in his mind, but reacting to what was presented to him at the time. Gets better. A person has the right to use deadly force on another person to defend himself or a third person if three conditions are met. He actually believed that the other person was about to use deadly force against him or a third person. It doesn't say that he thought the other guy had a weapon. It doesn't say anything. All this weapon stuff is an illusion. He doesn't have to risk him and see if he's got a weapon. In other words, the defendant can use deadly force if he actually believed that he or a third person was in imminent danger of death or serious bodily injury from another person. Serious bodily injury, ladies and gentlemen, can be as much as a sucker punch from a madman that breaks your nose or knocks you to the ground or whatever, okay? And folks, if you were looking at that film objectively, it almost looks like it could have just happened any minute. Any second, forget about minutes. There's a definition of serious bodily injury. For purposes of understanding self-defense, it means any harm to the body which causes severe, permanent, protracted loss or impairment to health or function or any part of the body. Not a bump or a bruise or a scratch. We're not talking, okay? That wouldn't constitute serious bodily injury. As the words imply, serious bodily injury requires a serious or significant injury. Any death, you can kind of get to that spot. Even if the defendant actually believes that such danger existed, that is, that either he or some other person faced an imminent risk of either death or serious bodily injury, that belief must have been reasonable. I'm going to stop right there. You saw everything. You heard everything. How could he not have a reasonable belief that this maniac, he said, when he came back at him the last time, he said, "You don't believe me?" In other words, there must be reasonable grounds for the defendant to believe that the other person was about to use unlawful deadly force against him or a third person. And here's the key. Self-defense does not require an actual danger to the defendant. He was about to use unlawful deadly force. Again, check that box. He must reasonably believe it. He said on and on and on and on and on, that he was trying to protect himself, that he was trying to protect his family. In the condition that he was in that night, that's what he was saying. A person's not permitted to use it to be interpreted from at the time that he was perceiving these events. The defendant can use the amount of force. Folks,
I think I might. Marissa's gonna come on, so the stream can keep on being live. Then I'm gonna shut the prop problems because of Blink here now. But I'm just waiting for Marissa to come on. So then as soon as Marissa comes on, she'll be on as an avatar. I'll shut everything down, start it up again, and hopefully that'll restart my internet, because my internet is going up and down, up and down. I lost connection to my own YouTube now. So we're just waiting for Marissa to come save the world. Talk badly about it. Well, badly about me when she is alone. Because that's the type of person she is. You can put yourself on screen. You don't have to sit back there and wait for me to do it. I'm gonna update everything and turn my internet off. And I don't know if Marissa's gonna talk, but I'll be right back.
Hello, everybody. I do not have the stream set up, so, and of course, no puppy. Oh yeah, that's my puppy. That's my little corgi girl when she was a baby. I'm not going to show the stream though, because I don't have it set up. But yes, the glitching was starting to drive me nuts, so I told Baker I would come in and help out, because if nobody sits here, then the stream ends. And that's not good. Let's see. Nope. Oh, good morning, Helen. I don't think I said good morning yet. Yes, I'm just babysitting. I mean, kind of useless. But how about that friggin' hanky-spanky trying to get the phone records between Karen and her lawyer? That's crazy. I'm sitting here waiting for the doc to drop, but I think it might be impounded, so we're not going to see it. But, whew, can't wait. Yes, chat definitely can't be left alone. But more like you would probably go away and hopefully I don't know. I don't have anything entertaining to say. Yes, Bev will definitely allow it. That's exactly what I said. I'm like, this is probably illegal and definitely infringing on some rights, but Bev is crazy. There's no strippers.
What?
I'm reading Brandon's. I'm just not bringing it up.
Oh. I think Brandon, it's Friday. He's
Brandon gets a little crazy on
He's
Friday.
listening to Rebecca Black and dancing in his halter top saying, "It's Friday, Friday, Friday."
I forgot about that song.
Brandon didn't. He's the only one who I think bought it at the time, and he plays it every Friday since then.
Nice. Well, you are much less glitchy now, so I think you should be good.
Yeah, I turned my internets on and off.
Awesome.
So I hope it's better now. And Iris is texting me.
I'm just going to slide right out of here and get back to work.
Gracias.
Yep. See ya.
Bye. Well, then you strip paint before you started painting. I can't see any legal way she can square that peg.
Reasonable. One can very easily come to that conclusion, that his reaction was reasonable because he was put upon by an unreasonable human being. That he was put upon in a savage situation with threats of death in the situation that he was in. Let me tell you something, okay? Jason went through quite a bit that night. Not only was he exhausted, not only was he threatened by this maniac, but he was trying to care for his daughter as well. He was worried about his parents. Of course he was worried about himself. And he was exhausted. So what happens after this thing happens? Is it somebody saying, oh my God, I'm going to run? No. Actions speak a lot louder than words. Jason Levesque stayed right there. He didn't make one move to leave. There may have been an off-cuff comment to his daughter that, quite frankly, is stupid and doesn't really amount to anything. He never tried to evade the police at all. In fact, there's evidence that he even dialed up 911 and just didn't hit the button because he heard the sirens coming. It came from him, it came from his daughter. And it also speaks to the fact that he stayed there. It also speaks to the fact that he made the firearm safe. He prepared for his arrest. He placed the firearm in the dash. He took the extra magazine out of his pocket. He secured that. And when the police came, he stepped out of the vehicle, he raised his hands, and he cooperated all night long with the police. That's not somebody that's fleeing. That's not somebody with a guilty conscience. That's somebody that's waiting and anticipating.
Sorry, I just saw this. Commonwealth's motion to compel communications. The Commonwealth seeks all text, emails, or written communications between the defendant, Karen Reed, and attorney David Yannetti restricted to those communications that occurred between January 29th and February 2nd. Pursuant to search warrant, the Commonwealth received the content of defendant's cell phone because of an observed attorney-client communication. The phone data was provided with the assent of the defense to the Attorney General's office, and court-ordered taint team protocol was implemented. The Commonwealth received the defendant's phone data with any privileged communication excised, given the defendant's public waiver of the attorney-client privilege is probably what it has to say. The privilege holder, Karen Reed, has waived her attorney-client privilege with Anthony Yannetti relative to any statements about her collision with John O'Keefe during the time of January 29th through February 2nd. The defendant voluntarily and intentionally disclosed the existence of these communications and her initial thoughts about her culpability for causing the death of John O'Keefe during various public. So they are saying because she talked, and I know it's only parts of it, so it's not fully there, but because she gave an interview to a journalist, she has waived her attorney-client privilege. I can't wait for a lawyer to talk about this. If you were making love to this attorney, would your safe word be ponytail, or would you just want to play with it and pick a less obvious word? Kumquat. Kumquat is always the word. Kumquat. So now you waive your privilege by talking to a journalist. I'm pretty sure I follow Mark Randazza on Twitter. Maybe he can give us an answer to that one. It's exactly, Special Prosecutor Brennan is an expert litigator. In all of his years of, he always do it this way.
And then cooperate with the police.
And again, I love that. Well, we only got it after the taint team. No, we don't know what's there, but we want their communication. This asshole have looked in her phone.
Just like an innocent person would. No resistance, no lip, no nothing. When they asked him to get in the cruiser, he got in the cruiser. When they asked him if he could go to the police station with no problems, he went. When we got to the police station, folks, you saw the video. I want you to watch that video. It's about 20, 25 minutes. Okay? And in the video clip, you're going to see a human being, all right, that is wiped out. I can't even describe it. This guy can hardly take his own sweatshirt off. He's cold. He's hot. He's nauseous. He's laying down on the floor of the interrogation room. That's just the beginning. There's almost 3 more hours of that. Do you think he got better over time? Do you think that's a good environment to get factual, actual, accurate information from somebody? Be surprised if he could tie his own shoes at that point. But they took a statement from him, a lengthy statement, and he was sitting there as long as they wanted to take it. This isn't somebody giving him lip. This isn't somebody that's resisting. This isn't somebody that's uncooperative. This is somebody like just what he said on the stand. He was just trying to help put it all together. Do you think somebody actually has a vivid, accurate memory? I'm going to ask you to draw on this a little bit. After being involved in a shooting, for the first time in his life, by the way. I mean, this guy doesn't even, like I said, he never even shot a chipmunk in his life. Do you think that doesn't shake you up? You think that doesn't scramble you? You think if you add that to the threats, that doesn't scramble you? You think if you add that to the fact you've been up for 40 hours, that doesn't scramble you? You think if you add that to the fact that all you're getting is a glass of water and a Slim Jim, that doesn't scramble you? That's the context of the 3 hours, over 3 hours, of interrogation with Jason. But did he complain? Did he say, no, I don't want to do it? No. In fact, the entire night, this guy is cooperating with the police. Can we search your truck? Yes. Can we take your video info? Can we take your cameras? Can we take your hard drive? Yes. Can we have the password? Yes. Okay? Yes, yes, yes. Will you speak with us? Yes. Can we swab your hands? Yes. Everything's yes.
It's from the day of the incident to the first arraignment. And again, if she wrote him and said, "Hey, Dave Yannetti, I killed a man. Can you cover it up?" He, of course, because he's not a scumbag, slimy mob lawyer, would say, "No, because now I know you're guilty. I ethically can't defend you." When you reach out to your lawyer, it's privilege. That's why even saying good morning to him is privileged. Everything's protected. It's
He's trying, okay? Was he perfect in the interrogation? No. And you know what? Nobody would be. Not under those circumstances. Nobody would be. The honest answer to that, he's doing everything he can, not only to help the police, but he's doing everything he can to try to explain what went on that night. He tried to do it with you guys. And you know it. He didn't have to take the stand. You know that, right? He didn't have to subject himself to cross-examination, and Attorney Barr's very good at it. He's been doing it for years. He's very good at it. He didn't have to do that. He didn't have to put up with that. Nobody forced him to go up there. Jason Levesque went up there because he wanted to look at you folks in the eye and tell you the best he could as to what happened. Not skewing the facts, not lying, not deceiving you, not playing games, not changing stories. Is it unreasonable, for instance, for somebody in that situation to not remember each and every time he pulled the trigger? It's an automatic. It goes on automatic. He's pulling. It's not done till it's over as far as he's concerned. And what's his concern at the time? Protecting himself, protecting his daughter, protecting his home. This thing happened right on the front steps of his home. Right in front, pretty much, where his mom and dad were sleeping. Right there. No lies and deception. That's a red herring. I'm going to urge you, take your time when you're deliberating. I'm going to urge you to listen to everything that's going on in those tapes that you have, watch everything that's going on in those tapes that you have. Okay? You know, Detective Garston spoke of tactics and, you know, training and all this stuff for interrogation. You know, maybe he was running an interrogation with tactics and training and everything else. Jason Levesque, he's not sitting there constructing a self-defense defense. He's not constructing anything. He's trying the best he can to cooperate with the police after a traumatic incident. A first for him, shooting anything that was living and breathing. And you'll hear Garston. You'll hear him in that tape. Listen closely. When his body cam is not switched off, and he's talking to another officer. And he says, let's talk to this guy now. Let's talk to him now while he wants to talk. They got him in their place. They got him while he's exhausted. They got him while he's easy pickings. And you know what? They know deep in their heart, they got a very frail human being that probably isn't going to be the best person in the world to get accurate information. They could have circled around 5 more times and probably gotten 5 more answers. Because even yesterday, Jason's not sure exactly of what happened that night. You know why? Because the body tries to stop remembering things like that. It protects itself. It goes into shock. It tries to get rid of memories like that. And those are difficult to bring back accurately all the time. There's nothing unusual about that. Any trauma situation, there's nothing unusual. It's typical, it's human, it's natural. Some of you may have experienced these things. Prosecution, in this case, for lack of a better analogy, was dealt a lousy hand. In order to get a conviction in the United States of America, in a courtroom like this on a criminal case,
We haven't really heard anything about that.
you got to hold aces. You got to prove the case beyond a reasonable doubt. Okay? No goofing around. No halfways. No maybes. No probablys. No could-haves. None of that stuff works. The only way they get a conviction in this case is to prove beyond a reasonable doubt each and every element of the offense charge, each and every one, beyond a reasonable doubt. And they have to disprove self-defense beyond a reasonable doubt. And in this case, ladies and gentlemen, they got dealt a lousy hand. They don't have 4 aces.
They don't have
You
40s
flip their hand over, what they really have,
or 4 aces.
a bunch of jokers. And the joker in the case,
That's good.
the joker in the case is Kyle Violette. They got dealt Kyle Violette. And when you get dealt something like that, that's a gigantic reasonable doubt. And when you get dealt somebody that acted the way he acted in a self-defense case, that's a lousy hand. But don't feel sorry for him. This isn't about sympathy. It's not about worrying about their case. It's about critically analyzing their case and making them prove their case beyond a reasonable doubt. You have to make them prove it. And if they don't, you understand that in the United States, you're doing your duty. You're doing your duty by coming through the doors of the deliberation room at the end of a trial and at the end of running through all the evidence, coming through and saying not guilty. That's the justice in the criminal justice system. It's not doing favors for the state. You don't do that. It's holding them to their burden. And I pray you do. I mean, there's a lot of junk that's going on outside of this courthouse. You all know. I mean, our country's divided all over the place. All kinds of junk going on. Maybe the purest form of being a citizen right now, The purest form of being a citizen in this country, the purest form of democracy in this country, the purest form of doing your duty as a United States citizen in this country right now is in courtrooms just like this, with jurors just like you. Think about that. You're really the reflection of this community, you know that. When you go back there, you're going to see you come from all different walks of life. You all have your own talents, you all have your own backgrounds, and you all have common sense. And if you all work together in this community, if you all put your minds together, all 12 of you when you get back there, you're going to come up with a very just decision by using your common sense, looking at that evidence, being critical of the state's case, and following the rules. So, ladies and gentlemen, I'm going to ask you. I can't do anything anymore for Jason. I can't do that. And all I'm doing is putting all of my trust in you guys. And so is he. So really, take great care in your deliberations. Be sure to follow the rules. Take all the time you need. And thank you again. I appreciate it. Really. Thank you. Thank you for insisting. Thank you, everyone.
I can't see Valhalla sharing a link anywhere. He's a mod. He should be able to do it. That's the thing. By the way, Doink the Clown has weighed in. It's actually the crime fraud exception to the attorney-client privilege that they are using, which is not true because the motion says that it's because she discussed it, their communications while a third party was present. But Doink, of course, got it wrong. There are two exceptions you can use. You can use if you are planning a crime with your lawyer or if a third party is present while discussing things. But Jemima's things, if these things are true, she may have a problem. I don't trust Brennan, so I hesitate. But if she did relay it in this matter, he got a good argument. She waived it by telling a third party about the communications. It's not good, but again, I don't trust Hank. So I want to see what defense response first, is what Jemima got. But let's see. I can find out what he said because I got the motion now. If I can get it to download. Tweak. That's not the right one. Let's see how he claims she waived her privilege. In this case, the privilege holder, the defendant, has clearly and intentionally waived her attorney-client privilege regarding specific conversations she had with Attorney Yannetti regarding the collision between her vehicle and John O'Keefe. For example, in the defendant's recorded interview with Gretchen Voss, the defendant concedes, "You never said, did I hit him? I hit him. I said, did I hit him?" And then, when I talked to David now, this is later, David said, "Karen, if you incapacitated him in any way, there's capability there." And I thought, all right, maybe this is what, I said to my mother, just to go forward a second, they were asking me, what was it like? Did they come out? What was the house like? Attorney Yannetti, Attorney Jackson, and Attorney Little were in attendance along with defendant and Ms. Voss. Second, in a Vanity Fair article entitled Karen Reed Tells Her Story, Part 1, A Murder Trial in Massachusetts, with a caption, As Karen Reed's second murder trial looms, she's ready to talk about what she says really happened. Published in 2024, the defendant, who according to the publication was notably aware that anything she said could be used against her, volunteered a rumor that alleged representations made by the Massachusetts State Police that there is text messages between her and counsel that implicates herself is a provable lie. What? Who, according to him, was notably aware could be used to volunteered a rumor. So she. Why is rumor put in funny bunny ears? That alleged representations made by the Massachusetts State Police that there is text messages between her and counsel that implicates herself is a provable lie. What? So Karen Reed told them a rumor that alleged that the Massachusetts State Police claimed the Massachusetts State Police have a text message between her and her counsel that implicates herself is a provable lie. I don't understand this. This makes absolutely no sense in Danish, English, or whatever language this is. The volunteer a rumor. So is it a rumor or isn't it a rumor? That alleged, so again, it's just someone claiming. Representations made by Massachusetts State Police. We have all seen those representations made by Plevin and Krusty that she told Giannetti, I did it. We all know they have been out there for a very long time, and they claim that was text messages. But it's a provable lie, which means even if she said that, she said it's a lie. So she can't waive privilege by that. And the first one, I can't understand how Jemima gets anything waiving here. Because the only thing, and when I talk to David now, this is later. And he says, if you incapacitated him, stupid words, in any way, there's capability there. And I thought, all right, maybe that is what, maybe. That's not admitting to anything. It's not because it's whether she waived her privilege by doing the Giannetti said this and I said that. She could have waived her privilege, but she doesn't state anything other than Giannetti told her, if you broke the law, you might be in legal problems here. How can that open up the floodgates for all of her communications? And the last one, body in the snow. The defendant professed, and then when I hired David, I asked him those questions the night of January 29th, like, David, what if I don't know? What if I ran his foot over? Or what if I clipped him in the knee and he passed out and or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability. So that's how I thought about things for about 3 days. So she asked her lawyer and he gave her legal advice. I can't see how that can open up for any other than these specific conversations. I can't see how that is. The privilege holder is the defendant. The defendant intentionally waived her privilege by disclosing her conversations to a nationwide audience with her attorney. The attorney-client privilege can be waived only by the client. In addition to rendering the communication non-privileged, the communications are relevant as admissions and statements of the defendant. These statements are admissible substantially, and attorney Giannetti's statement to the defendant are admissible pertaining to the defendant's state of mind. Again, this fucking state of mind has nothing to do with any of this. She was asking her lawyer. She was asking her lawyer what legal problem she could be in, and he answered, and that showed her state of mind. Yeah, it showed her state of mind that she was asking her lawyer, what if any? No, I don't want to do that. Yeah, but it can't waive her entire privilege. It can only waive it for the parts she talked about. She can't waive it. Yeah, but still, it can't open if she then had a conversation about trials, anything. I can't see how that can open the door for everyone. So they can, in my opinion, this only waives the privilege pertaining to the things said in front of third party. Because it's a press strategy like every other case. There's nothing special in this one. Which I hope that defense fires back and asks for all communication from the MSP to Caffey Daffy, Plevin, the fake victim, Krusty Pandies, after this one. Well, I would say, shouldn't that conversation, her referencing that she talked to her lawyer about certain things, shouldn't be the same as having the conversation in front of the lawyer? Yeah, that's what I... Yeah, but he's asking for everything in 3 days. He shouldn't be allowed to do that. And again, they have to make the statements that in a text, I ask David Giannetti, hey, David, what if I ran his foot over? She's stating generalities that I asked him and he answered me. He's not saying we had a text message where this and this happened. Again, the person wasn't in the room. So I can't see how this is the same thing. It can't be waived by communicating past conversations, but it's not a conversation. It's a summarization of what they talked about for 3 days. It's not on the 29th, I told him and he answered me. I can't see that it's the same as bringing in all of their conversations for those 3 days. It makes absolutely no sense, not even in the third party observer, because the conversation didn't take place in front of a third party. She's referencing a previous conversation she had with her lawyer, but she's not talking in specifics. She's talking about, I was asking him questions and my mindset at that time was, what the hell is going on? Yeah, just start all over again. I don't know. Yes, you did. I'm not saying that, but I'm still saying she's not referencing specific conversations. That's why I don't believe he can open the door, because as I read the things, it has to be to a specific conversation. She's just saying, well, we talked about it. Yeah, but I can totally see that. And again, it's Beveridge. She can read it the same way that you did, that there could be merit to it. But again, it's not what it's about, because it's the criminal part. I read that on Doink, and I trust Doink more than any legally trained person in the world. Doink was a one-year law student. He almost made it.
Now, I want to talk about two words that were touched on in that presentation. But I want to talk about the
But doesn't she have to ask a specific? There's nothing specific in the statements that we just read. It's generalities, and he said yes. If some of this happened, you could have culpability. He doesn't say. She doesn't say, "I hit him," which is what all the idiots are always claiming. She says, "What if any?" Yes, it's. I only trust Doink.
those two words in the context of the shooting. Before and when Jason Levesque decided to shoot. This isn't a case just of a shot. This is 6 shootings. And I want to talk about these two words in that context. These two words are reasonable and imminent, as about to. And to be clear, these are not just words. These are the concepts and principles of a sensible law that buttresses against inappropriate and unnecessary deadly violence. Violence driven by notions of retribution, revenge, impulse, anger, and poor judgment. We guard against that with these concepts. These principles exclude.
I just read his affidavit, and he says, I have reviewed several public statements made by the defendant relative to this, including to blah, blah, blah. The Commonwealth's intent on introducing... Jesus Christ. Now I have to share this because, again, I'm dyslexic and I read 5 lines and I find the first mistake. The Commonwealth intends on introducing... Oh, maybe I should share it. Introducing and number of the defendant's statement, including the statement included in the attached motion. Probably should put a comma there. Pursuant to a search warrant, the Commonwealth is in possession of the defendant's cell phone data. The data is subject to a taint team protocol, and any redacted communications are not available to undersigned counsel for review. I bet you looked. Undersigned counsel request this court review any redacted communications ex parte and provide the Commonwealth all relevant non-privileged communications as requested in the attached motion. I believe the communications requested are non-privileged because the discussion with Janetti during the requested time frame and subject matter of the defendant striking John O'Keefe have been intentionally disclosed to the public by a privilege holder and no longer confidential. But did she striking John O'Keefe? She asked if he had ran over her foot. Again, why is this wannabe drill sergeant yelling at me? Are you talking about Jemima? Jemima doesn't yell. That's Jamie. She sends Jamie out to yell at you. So if you get a call and someone starts screaming, then it's Jamie. Go back to the last point. The last point in this or in the affidavit or in the motion. I think it was 6. Yeah. I believe the communications requested are non-privileged because the discussions with Attorney Janetti during the requested time frame and subject matter of the defendant striking John O'Keefe have been intentionally disclosed to the public by the privilege holder and are no longer confidential. That's 6. So because she discussed it with him, she lost her privilege. But again, he's using this for state of mind. Where's the legal authority? Is it in the motion? He's just playing word games. Burkhardt says she loses privilege. Well, I don't know. Case law is Massachusetts R. EVIT 523 provides who can waive conduct constitution waiver to ensure that only the communications that were waived are provided. The Commonwealth requests that this honorable court review in camera all text messages and written communications stored in the defendant's phone for the time between 29th and February 2nd. In this case, the privilege holder, the defendant, has clearly intentionally waived her attorney-client privilege regarding specific conversations she had with Janetti regarding the collision between her vehicle and John O'Keefe. You never said, did I hit him? Did I said, did I hit him? And then, when I talked to David. So, this part is out. That's not what she talked to David about. Now, this is later. At what time later? And David said, Karen, if you incapacitated him in any way, there's capability there. So this is waived. That if you did something, you have capability. And I thought, all right, maybe this is what maybe. Said to my mother, just to go forward a second, they were asking me, what was it like? Did they come out? What was the house like? Attorney Janetti, Attorney Jackson, and Attorney Littleworth in attendance, along with the defendant, Ms. Voss. So nothing in this statement relates to any conversations with David other than him giving her the clear, I could have given her this information. If you incapacitated him in any way, there is capability there. Right? Because this part that he put in there has nothing to do with her conversation with David, because that's clearly when I talk to David. Now this is later. Why can't I remove this? And then, when I talk to David, now this is later. So this part of the text has nothing to do with is waived. Right? In the matter of a John Doe grand jury investigation, 408 Mass 480 is the case is cited. But we are agreeing here that the only thing that could fall under waived rights is David Janetti says, if you incapacitated him in any way, there's capability. Shouldn't that be culpability? That's all of this is the only conversation that is with her lawyer. It doesn't matter that they were present because they're not. This isn't anything to do with the conversations with the lawyer. Am I totally wrong? I'm pretty sure I mean culpability. Yeah, I don't know. Yeah, of course Bev is gonna but out of this statement, what he can then have Bev look for is, did she ask him, do I have culpability if I hit him? because that's the only statement that has to do with a lawyer in the entire, except he then puts in that, well, the lawyers were there as well. That has nothing to do with their privileged communication. The Vanity Fair. She volunteered a rumor, which is just a rumor, that alleged representations made by the Massachusetts State Police that there is a text message between her and counsel that implicates herself is a provable lie. So this entire you can just toss this out because this has nothing to do with anything other than the Massachusetts State Police alleging that there is she's implicating herself in a text message. All of this has nothing to do with anything. I don't think that example 2 is a waiver. No, because that has nothing to do with her doing anything other than just saying, and the Massachusetts State Police claims that I implicated myself via a text, which is a provable lie. And then we have this one. And then when I hired Dave, I asked him those questions the night on the 20th, like, David, what if I don't know? What if I ran his foot over? Or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability. So that's how I thought about things for about 3 days. Again, it's the same thing in the first part. If you did anything, you're guilty. You have some culpability. Again, it can't waive it can only waive pertaining to her asking a question, what if I hit him? And what if isn't I did? Yeah. Yeah, she's saying, what if, again, I ask him those questions. What if, I don't know, what if? So again, it's questions. It's questions she asks. She's not telling him, David, I hit him. So even if she waived privilege, Jemima, I know you are working. You should stop working and come talk to us. But even if these two things are waived, it's only pertaining to these two things, which is the same thing. I asked David, what if I hit him? And David answered me, yeah, then you have culpability, which is nothing you need to ask a lawyer about, because when Jamie hit me, she was culpable of hitting me. 1 and 3 is exactly the same situation she is referring to. And the second one is just, I think, again, this is stupid. I'm not, this was written before yesterday. But the entire second part is her talking about the MSP. It's not talking to her counsel. It's MSP claiming that there is a text between her and counsel. That can't waive it. Yes, and that's why it's only the communicate. Yeah, but you can't blanket. You can't go in there and search for every single piece of communication she had with her lawyer, because he's only asking related to, and that's what it says down here. In addition to rendering the communication non-privileged, the communications are relevant as an admission and statement of the defendant. It's not an admission asking a question, what if? These statements are admissible substantially, and Attorney Yannetti's statement to the defendant are admissible pertaining to the defendant's state of mind. Yeah, that he said, if you did anything, you could be guilty. the defendant's admission. There's no admissions, there's questions, and Janetti's statements are relevant to challenge the defense's later purported claims of third-party culpability. She makes no admissions. She makes no admissions. The communication have relevance to rebut the defense's potential claim that some other person committed the crimes that caused the death of John O'Keefe. Moreover, the defense has suggested as part of the defense, it's likely to pursue a Bowden-type defense. The potential evidence is relevant to rebut claims of law enforcement contrivance. No, it's not, because it's still a shitty investigation. She makes no admissions in those statements he had. She asks, what if? Which isn't an admission. He does cite case law because he's putting in the Massachusetts 523 waiver of privilege. But to ensure that only the communications that were waived are provided. So the only things that could be provided is her asking the question, what if I hit him? Now down. This is what we had. This. Is it this one you want, Brandon? This is waiver of privilege rules. It's not case law. Read the paragraph on the case. I don't know what paragraph you want me to read. This is who can waive privilege in a case. Read the paragraph you keep skipping over about John Doe. Lower, go lower, lower. There's no John Doe in this. The John Doe was... I'm only paying attention to Mart's. I'm actually trying to look at everyone's. But there's no John Doe mentioned in this one. The John Doe was when Jemima pulled up what it is. There's no John mentioned in this text that I can search. Read the paragraph you keep skipping about John Doe. Lower, lower, lower. There's no... John Doe doesn't say anywhere. What am I missing that I'm not seeing? It's above the last thing you marked up. This is here. Communications confirmed by the defendant to exist are no longer privileged nor confidential because the defendant chooses to widely publicly disseminate them. Scroll down. Jesus Christ. It's above the last thing you marked up. In this case, the privilege holder defendant has clearly intentionally waived her client privilege. That's John O'Keefe. It's past that page. Keep going. Oh, in the matter of John Doe grand jury investigation 408, that's the one. So this is the one. So this is the part that the privilege holder is the defendant, and the defendant intentionally waived her privilege by disclosing her conversation to a nationwide audience with her attorney. The attorney-client privilege can be waived only by the client. Miss Little, do you have a page number? Yeah, this is the case law. No, they're not. Again, this is a fishing expedition. And again, none of the statements that he alleges says what he alleges they say, says what he alleges they say. The only statements I can read that he claims is there is, I asked, what if I did it? What then? And he said, then you would be culpable for a crime. She never said, I did it. And I know that multiple short bus Smurfs have claimed that she did that multiple times, which is not true. So again, I'll cry when I find out. She's only asking question. Hank doesn't know his behind from a hole in the ground. Yeah. Oh, Brent. I must have paid $2. I didn't. But it's crazy. As far does that go, though? Do they search for every time she asks him, what if I hit him and what if I did it? And then everything with those word phrases are allowed. I would, again, I'm not a lawyer, but it can, in my opinion, and that's what he asked for, is anything that's related to the statements made here. Those statements are, what if I hit him? What's the problem? It doesn't show her state of mind other than she was trying to figure out what the hell is going on. But he's again trying to... why did I put rates? Jesus Christ. It's not working. It's because Brandon yelled at me today. He's as mean as Jamie. It's not the same as she waived all client... It must be curtailed to only the statements he's asking about. And again, she's asking a question. She's not making a statement. She didn't say, Janetti, I hit him. How do we hide it? She said, what if? Which should be a totally cromulent thing because they didn't know what was going on. She was being taken out of her house and put into jail and called her lawyer. How do they know the text exists or what they say? Well, allegedly she said it, that the text existed, which she didn't say. She said she asked her lawyer, but they then use, probably because they looked into what's in the taint team that they're not allowed to look at, that there is a text where she asked something, and then they confused everyone by saying that thing about the MSP alleged there was a text saying it. Hank couldn't watch the first trial, so he used the Cliff's Note version by reading short social media. I think he sadly went into Plevin stream one night. They're just using the facts. He said, I texted something to the effect of, to just go through a phone dirty, but if it works, why not? Guys are dirtbag. Yeah, again, if you're going to wrestle pigs, you're going to get dirty. Exactly. Seems like the Commonwealth's aware of a text between the three amigos that trigger the crime fraud exception for attorney. No, because they don't invoke the crime fraud exception here. She only said that because they said they had ring camera of it. Exactly. That's probably why because she said, I don't believe I hit him, but they said I have ring camera of it. Well, we're going to figure it out when smarter people talk about it, and I'm going to get beaten by Jemima later. I'm taking a bio break.
each motion through this process. Not to dissect, not to impose some unreasonable
because
analytical
we were
approach to
sharing screens instead of
Mr.
sharing
Levesque's
feeds.
choices, but to assess his choices and his actions appropriately. Evaluate each one of these steps, these sequences, and you'll see that at each stage, after the initial confrontation, there is actually a cascading sequence of diminishing risk. From the moment Kyle Violette stepped away, there was diminishing risk. And I want to ask you to evaluate the steps in this case concerning issues like distance. Distance creates safety. Evaluate it. Distance can be closed and increase risk. Distance creates opportunity to assess risk. So in each one of those chapters of this case, consider that as a factor. The time. Attorney Sisti said this whole thing happened in 11 seconds. You'll have the totality of the videos. It took more time for Kyle to walk across from his driveway over to Justin. I mean, to Jason. There was 5 seconds between, nearly 5 seconds between that first shot. 2001, 2002, 2003, 2004, some 5 steps towards him before he unloaded the remaining 5 rounds into his back. Consider that distance and time when you assess reasonableness. Visual opportunity. The opportunity for Mr. Levesque to assess risk. The lines of sight here, the lighting. Remember at the beginning, there was one moment in Attorney Sisti's cross where Detective Danny was saying, look, you don't even know whether or not Jason is able to see his hands because of the lighting. And yet, we see a video from 43 where inside, from 40 feet away at least, Angela is able to say, he's got a gun. The lighting in this case was very good. Illuminated by a high-density residential neighborhood with exterior lighting. You can see it in the video, a truck with its headlights on. And Angela having no problem identifying immediately when the gun was taken out, when Jason produced the gun, which informs you about Jason's ability to assess whether or not Kyle was armed. And so those are some of the issues to talk about, to consider when we actually walk through this. And let's do that now. This confrontation starts when Kyle walks out of his home. And despite Attorney Sisti saying at some point, challenging Danny, that Jason doesn't even seem to know he's there until he's at the plow, we know this, that when Kyle was walking out of his home, Jason did see him. He had a full opportunity to view him from the full 40 feet here. You were out there at that scene. You know that distance from the far end of Kyle's driveway all the way over to that plow. And we know he saw him because he told the police, I saw him putting on his shirt. You don't have to believe him. It's corroborated by the video. So we know he saw them at that point. And what does he see? He's putting on his shirt and he's able to describe his hands. You know, this is an informative moment about whether or not there are reasonable concerns about Kyle's ability to cause violence to such a degree that would justify what happens next. And nothing in his hands. You can see him putting on his shirt. There's nothing underneath. No reasonable basis to believe that he's armed coming over. Jason admits that he can see his hands, that there are no weapons, that there's no means of imminent threat as he's walking over. And let me just address this one point that Attorney Sisti said, that no weapons is just an illusion. It's a red herring. That's nonsense in a case like this. It's true that there's this phrase in the instructions that say, look, he doesn't actually have to be in danger. But that means if somebody presented a firearm that was carved out of balsa wood and painted black, the actual threat of that is zero, but the perception of it could be reasonable. That's not this case. There still needs to be a reasonable apprehension that Kyle had the means, the ability to cause lethal, deadly force. And obviously something like weapons is highly relevant to that reasonable analysis, is it not? The face-to-face encounter. It's clear that there is contact. Jason's description of it actually says the tip of his nose touched my cheek.
What the hell? Sorry.
Let me be clear about that. There's nothing that's sort of appropriate. I'm not suggesting that's a good deed. Let me just clarify this point. It's non-deadly force. There's no suggestion that he is going to kill him with his nose. I don't mean to sound glib about that. I mean literally to say that dismissing that he didn't have a weapon and say that the encounter there is what drives this analysis is misplaced. Here's the reality. That moment passed without the use of deadly force. That's not when the shooting happened. And yet, in this...
Did Hank cite the wrong law, Marissa? In the matter of a John Doe grand jury investigation, 408 Massachusetts 480. Yeah, that's the one he is using. They want an attorney to testify about his dead client's conversation with him. We begin by stating our answer to the reported question is as follows. No, in the circumstances shown by the record, the attorney-client privilege should not be overridden. The rule which places a seal of secrecy Yeah, but the ruling made is that they conclude by repeating our answer to the reported question, which is no, in the circumstances shown by the record, the attorney-client privilege should not be overridden. And it's a total separate matter because this is admitting a crime and then dying. And then Jay Nolan has a dissenting motion saying it's the dissenting motion, right? As I read it, it's the dissenting motion that he's relying on, because the dissenting motion says, is the product of hallowed tradition despite the majority's inflexible ruling today. However, the privilege is not absolute. Several exceptions has been carved out over time in the context of parties claiming through the same deceased client, disputes between clients who share a same attorney, communications involving a client's intent to commit a future crime, and deceased client's instructions to drafting of a will. I can't see the case law, or I can't see the ruling, because there's a dissenting argument from Jay Nolan claiming that you should waive, but the ruling is no, in the circumstances shown by the record, the attorney-client privilege should not be overridden. So I'm not a lawyer. I don't know anything.
Courtroom, that is what was recreated by the defense. We literally had a recreation of the face-to-face, the nose-to-nose encounter. And you know what we never got to in that presentation, that recreation? Was when he took out a firearm, closed the distance, saw Kyle stop, turn, and shoot him in the head. Lower the gun and then advance on him and shoot him 5 times in the back. We didn't see that recreation, but that's what this case is about. It's on tape. That's an ace. Each one of those videos is an ace.
I'm pretty sure that case doesn't work for his argument because this case is waiving privilege when a defendant is dead, and they conclude it doesn't waive privilege. We need to get through this, and I think we need to have a group chat behind the scenes, and someone has to enlighten me. It's not the same. This is a dead person's lawyer. They want to testify. It has absolutely nothing to do with what he's asking.
You know what could have happened at that?
The dissenting opinion again isn't even that clear because that has to do with criminal, future criminal intent and stuff like that.
Nose-to-nose assault, that's the definition of non-deadly force. And you know what Mr. Levesque would have been fully within his rights to do? Shadow, that is to use non-deadly force in response. That is another corollary of self-defense. You can defend against non-deadly force with non-deadly force. He may have even deserved a punch in the nose. Reasonable force. But to bring that whole episode forward as justification to shoot him is not reasonable. It is the most intense moment of this entire episode. And yet, that's not when he was shot. And that moment was defined by non-deadly force. His hands were out. He had no weapon. He didn't claim to have a weapon. He didn't hint he had a weapon. Even in that moment, there was no reasonable basis. If he had shot him, would have no reasonable basis to do so, and he didn't. The moment.
And the stronger it is, the higher the likelihood I would accept it. Wasn't that what she said yesterday? That only Massachusetts law worked.
Passed. He made a threat. We accept Jason Levesque's characterization of that threat, repeatedly made to Detective Garson. Never wavered about that. Not too tired to use the term, that was verbatim. Not too confused to say those were the exact words. Not too confused to repeat the conditional threat over and over and over again when Detective Gersten revisited those issues to do his looping. Tell me what he said? Every single time it was a conditional threat. I want to talk about that. Let's be clear. If words are the basis to justify killing somebody, then words are really important. A conditional threat, these aren't just legal concepts, I gotcha moments from the law. These are common sense analyses of words. A conditional threat is important, it's different, because it literally buffers and defers both the act and a time period of when a threat may come to fruition. I know that sounds all legalese. Put it this way, something needs to happen, and it's going to happen in the future. And that diminishes the nature of the threat. It's not, I'm going to kill you for what you just did. That's imminent. Brandish a knife, I'm going to kill you for putting the snow next to the pole. It didn't happen. Something else had to happen. And it would happen in the future. And then, still, Kyle would have to have the means to actually do something lethal and violent. There's some pretty common sense examples of this notion of conditional threat, From this, the real world. If you flirt with my girlfriend in the gym one more time, I'm going to kill you. The guy says, fine, I'm not flirting with your girlfriend, I'm not going to do it anyhow. If you cut me off in traffic one more time, I'm going to kill you. It's a conditional threat. I'm not going to kill you for cutting me off. It's different by nature, by assessing reasonable risk.
I just made a tweet saying, Karen, watch out. Because you never know. Sorry, did I miss a memberversary? Thanks for a wonderful 8-month Baker and chat. Thank you, Holly Mac, for being here. Sorry, I'm just looking at case law and a ton of other things, and I don't get a ding when these things happen. So thank you so much, but thank you for telling me.
Let me just talk about this condition, too. You want to know what the biggest red herring in this case is? It's where Jason Levesque put the snow. That's actually the point. Attorney says he got up multiple times.
Yeah, but you also said I was slow in French.
To point out with different witnesses, hey, that's not on his property, is it? No, it's pretty close. You heard from a bunch of different witnesses. No, not on the property, on his property. That's the point. The condition of the threat hadn't happened. And Kyle is literally saying that. He's not saying you put snow on my property, therefore I'm going to kill you. He said, if you drag that stuff out of your driveway and push it down in front of my driveway, then we got this problem. Didn't happen. According to Jason, it wasn't going to happen. And that literally redefines the notion of this threat. That's the point. It didn't happen. You can actually see Kyle continue to explain the conditional nature of it when he walks away from this nose-to-nose encounter. He's pointing at that snow and his own driveway. That needed to happen. And it diminished.
Thank you, Stacy Labruno, for becoming a member on this day where everything is kind of weirdo, outo, and then she is calling me slow in French. But welcome on board. Please use all of the Sue emojis you want when the Danichi is making fun of me. Hey, little D.
Any notion that Kyle Violette is about to act on anything. I mean, the law actually recognizes this distinction. This notion of complying or not complying with a threat. Here it is. This is in the justification of self-defense statute. A person is not justified in using deadly force on another to defend himself or a third person from deadly force by the other if he or she knows that he can comply with a demand that he or she abstain from performing an act which
Slidey Pie, I think you're behind. I fixed the sound.
he or she is not obligated to perform. That's a very legalese definition of conditional threat. In other words, if you don't have to perform this pushing snow in front of the driveway, of Kyle's driveway, you can't use reasonable force. You can just not do it. Here's the difference. If somebody comes up with you with a knife and says, look, give me your wallet. You don't have to comply with that. You can take your gun out in the face of a knife, in the face of the threat of something that you don't have to do. You shoot them if you want them. Somebody comes up to you with a knife and says, hey, look, if you ever come into my home again and steal my wife's jewelry, I'm going to kill you. You don't not only have an obligation to go into their house, you have an obligation not to. So it's sort of a very clear example of a conditional threat where you don't have to comply with it. There's nothing about pushing snow in front of in front of Kyle's property that he had to do and was therefore imminently threatened by it. And I get, we're spending a lot of time on this. My point is, in this particular case,
welcome, Stacy. I'm glad to see you.
Let me also just talk about the law, doesn't take away all options. I think we talked in Vladimir about sticks and stones can break your bones, but words will never hurt you. And that's a kindergarten notion of it. And we accept that in the real world out there, words can be scary. And threats that you probably don't hear in kindergarten, like, I'm going to kill you and your family, didn't come around. So there is another layer. And it's this. You're allowed in New Hampshire, under the same justification self-defense law, a person who responds to a threat, and this is as opposed to imminent deadly force, to a threat which would be considered by a reasonable person as likely to cause serious bodily injury. In other words, the basis of the threat is something like, I'm going to kill you. You can respond to that by displaying a firearm or other means of self-defense with the intent to warn away a person making that threat and you don't commit a crime. The law has anticipated this very moment where it's just a threat, but not imminent use of actual deadly force. But the threat of deadly force, if you're armed, you can produce your firearm and say, no, you're not. It says nothing about them being able to shoot them for retribution, for your anger, for your offense, for your sense of honor. You can warn them away if it's a threat. And to be clear, Jason Levesque never claimed a standalone threat. He got up on the witness stand and made that claim because he's got to. He's got to get away from this notion of conditional threat, got to get away from the notion that he was just entitled to brandish a firearm. He got up there and said, after the nose-to-nose encounter, he walked away and said, you don't believe me? I'm going to kill you. Here's the problem with that. It's a credibility issue. when he talked to the detective. He didn't say once, he said twice, in clear terms. Again, this looping effort to clarify, is he committed to this specific issue or not? Said he stepped away, he was walking back towards his house, it was after the gesturing, and Kyle turned at some point. You got to ask yourself, was that in response to the defendant saying something? Because his response, according to the defendant that night, was simply, what, you don't believe me? And that had him walking back, sounding very much like an exchange. The bottom line is, no, there was never an additional standalone threat despite his claim. You saw this process work out, how it works. I showed him the transcript, 2 places where he was very clear that there was no standalone threat, and he said, oh, it's in there. It was in there, you saw the process work.
I think Boogie's biggest problem was he fired a warning shot, which is, I believe, illegal in every state in the country.
Yeah, his attorney could just as well get up there and show the transcript where I was being tricky and omitted it and say, oh no, here it is. That never happened. The reason that never happened because it's not in there. Jason Levesque never claimed there was a standalone threat. They say there's nothing appropriate about that threat, but Jason had legal recourse to brandish his firearm. Does this case change over his claim that his daughter was threatened? It doesn't. The same reasonableness, the same imminency of deadly force would have to necessarily apply to the daughter. And here we know, I'm not saying it's appropriate, but here we know that he never used even the term daughter. We don't even know that Kyle was aware that she was in the truck because he never gestured towards her, never pointed towards her, never invoked her name, or even specifically daughters.
I don't know what's wrong with the Northeast, but apparently snow turns them into a murderous rage. I think it's because they never see snow up there.
Broad brushstroke, horrible, inappropriate
Pommy
threat,
country.
but not one that imminently targeted his daughter, not this case. We talked in kind of candid terms during voir dire about, whether threats change for you if they concern your family. And of course, everybody's initial visceral response was, yeah, you threaten my daughter, I'm going to kill you. And that may well be, a natural initial reaction. But this is for real here. This is now the application of the law and the consideration of real-world consequences. It's not a conversation with, your friends and family around the dinner table. This is what I'd do if somebody said that. This is the realization of what actually happens, when you shoot somebody in response to being offended, to thinking there's some street notion of retribution that is appropriate. This is real world. And now we're going to apply real-world standards. What happens next was the walk away and return. The walk away is important concerning, again, 2 issues: time, space, opportunity, diffusion of risk. Kyle walks away at least 15 feet away. The nature of the threat necessarily diminishes. If he has a screwdriver that is, sort of fancifully filling Jason's mind, he hasn't not only referenced it, it's purely fanciful. It's not a reasonable belief, but from 15 feet away, screwdriver isn't going to do much good. This whole issue of, well, he didn't go through a mag detector, so Jason didn't know whether he had a weapon on. There's no reasonable basis. He didn't reference a weapon. He didn't display a weapon. He saw his hands clear. But here's something to consider. What Jason Levesque knew was that Jason Levesque was armed. In other words, from that distance, he could have easily, if he was really concerned about imminent use of force from some weapon, he could have drawn his weapon. And at that point, still, he does not. Kyle is gesturing to the snow, gesturing back, really corroborating, if nothing else, just his conditional threat that snow needs to be moved before we have a problem. He turns back to his own house, and as I said, there is no new threat. His hands are in the open. But he does clearly walk back towards Jason. Response to, again, a comment or an exchange. We don't know because we can't pick it up on the audio. And then again, he brandishes the firearm. And the state concedes he's within his rights based on that threat statute. I said you can brandish it to a threat. You can't use it unless there's imminent deadly force. And here's where things go south for the self-defense claim. This is the ace, the second ace. It worked. Brandishing the firearm worked. You can see Kyle Violette stopped. And it's not milliseconds before he was shot. There is time, revisit this on the...
We do the same here in Denmark when we get snow, because I live in an HOA. We have a guy who will come and do like the pathways and do the parking spots and stuff like that. But if I lived in my own house, I'm legally by law, I have to keep my section of the sidewalk free. So I would have to go out and shovel that. You rarely see people have any snow plows or those whiskers unless it's a business, because again, it snows that bad every 3-5 years. But then the main roads will be plowed by the city first, and then all the side roads. And then sometimes, yes, they will just plow it in front of your driveway, and then you'll have to go out and shovel your driveway free. But that's part and parcel of those days of snow. And again, you leave it on your own ground. You don't throw it into your neighbors. Yeah, well, idiots do idiotic things. I had my neighbor complaining because I have a fence out there, and then underneath it there's some siding board, so stuff won't fall under. And mine had been broken, and I've been thinking about changing it for the last year. I haven't done anything about it because, again, I always go out the other side of the house. Then he texted me if I could fix it because leaves fly into his yard, which it can't because there's a wall there. And so I said, fuck it, I don't want to all his complaints. So I went out, bought a new piece of siding, put it on, everything's fine. And then I took the old pieces and threw into a plastic bag, and then I'm going to go to the dump on Sunday. This morning, I could see him rummaging around out front because I left it by the trash cans. And I went down and said, just relax. You don't have to go through that bag. I'm taking it to the dump on Sunday. I wasn't. I said, I can tell you've been moving the trash cans around. I can hear it from in there. It's gone by Monday. Just relax. Oh, yeah. By the way, thank you so much for doing it. Yeah, go yourself. And he wanted to complain to the HOA, and the HOA president, oh, by the way, I'm on the board of the HOA. The president was like, we can't do anything about that. Is he in the... Well, I can't say that. Stupid people are everywhere. Well, I'm not sure Kyle was doing that because no indication they ever talked before. And his wife had that, I hope he doesn't do anything stupid. Oh, our guy is really good at not. But sometimes it'll pack up behind the rear wheels.
On the video, and I don't mean in a hyper-technical sense. View it from the claim that Jason Levesque is making. Oh, this was a millisecond. It's not. He pulls out his firearm back by the plow, and he starts closing the distance, clearly indicating he knows he's in control now. You don't close the distance if you're afraid somebody's going to bring out a weapon, a throwing screwdriver, or anything else. He closes the distance, raises the firearm, and with unambiguous certainty, Kyle Violette stops, and he doesn't merely stop, he turns away. And you can see this from multiple angles. You can see this from that garage view. You can see it from the side of the house view. You can utilize the evergreen where you see him just come into view. Gun comes out, and he goes out of view. You can see it from the porch perspective, which is down at the feet, imperfect. But critically, what is visual is that his feet become reoriented, stepping away. Both feet are now oriented to across the street. He's clearly turned. This is before he's shot. That's time. Opportunity to see the threat diminish, to see that the brandishing of this weapon accomplished its end as justified in the law. And yet, he closes on him and discharges a firearm into his head, into his face, crashing through, smashing his jaw, and dissecting his carotid artery. He's in control. that was entirely unnecessary, unreasonable, unjustified. An unarmed man stopped and turned away from his gun. He tried to kill him. The next 5 rounds, he shoots him
Attempted manslaughter. Attempted murder and attempted manslaughter, I think.
in the back. The time frame is something like, and you can listen to the video from across the street that's just audio. It captures the first gunshot clearly. And do the count. Something like 4 to 5 seconds. Think about that. 1001, 1002, 1003, 1004. Bam, 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 bam. It's unconscionable. He's on the ground, crawling for his life. That's attempted murder. By the grace of God and the intervention of immediate medical assistance, he lived. But that's attempted murder. You know, this is incredible claim that we heard yesterday. You know, I asked him, do you think he's still a threat to you? Yeah, he was crawling towards my parents' door. Literally said that. That's incredible. It's like the cyborg scene out of The Terminator where the thing is crushed and still crawling on the ground and it's, you know, pursuit of murder. Except this isn't science fiction. The fiction here is from Jason Levesque that Kyle crawling on the ground with a nearly lethal, certainly would have been lethal without intervention, gunshot wound to the head presented some sort of threat to him, his family, or anybody else. The other thing he's crawling towards is his home. And that's obvious. And once again, we know there are other factors to show that Jason had no sense of impending threat or injury to him. He lowers the gun. You can see that in the video. He lowers the gun before he advances some 3, 4, 5 steps closer to the supposed threat before he unloads the additional 5 rounds into his back in lethal fashion. Look, you got to analyze that in terms of reasonable force, reasonable belief, and the imminency of threat. These are the moments. It's not the nose assault. Let's talk about intent to kill. We need to prove that. You can form a purpose within the meaning of the law in a moment's time. You need to have the conscious object of a certain result. There are plenty of practical examples of this, of bad decision making or regret doesn't take away the purposefulness of a decision. Geez, I shouldn't have had that extra martini. It didn't mean I didn't take out a shaker, a glass.
Damn it, they removed all my accounts. Now I have to figure out the passwords again. I need a map on the wall beforehand. Thank you, Brandon. I'll make a map for you.
Pour gin into my martini glass. I may regret that, but I certainly still acted purposely. It can happen in a moment's time. A decision to pick up this glass or that glass is still a conscious object and a decision. Here the steps, though, are much more conscious and involved. Each act purposeful. To take out the gun from a holster, to raise it and aim it, to advance towards a target to ensure greater accuracy and lethality, to pull the trigger, to watch him fall, to watch him crawl, to advance on him, to aim again, to pull the trigger each time. This is not an automatic weapon that just sprays out 6 bullets. Each time he pulls the trigger is a purposeful, conscious act seeking to create a result. That's an ace. Look at the nature of these wounds. A headshot. 5 additional shots that each found potentially lethal marks. He's got shots in both buttocks, clearly indicating he's not a threat, but all those shots were potentially lethal. You heard the doctor say that each one was in an area of critical vascular, nerve, and organ systems. So one of the bullets through his buttocks blew out his abdomen, dissecting his bowel, requiring emergency surgery. Need I go into the details of these images, which the defense on the one hand dismisses as unnecessary, but at the same time,
See a map of Denmark, the only sexual arousal country in the world.
Jason Levesque gets up there and he is asked that critical question: why did you shoot him? Did you intend to kill him? No, I just wanted to stop him. Look at those images. Play that body cam of Sergeant Hurley saving his life. And you got to ask yourself, is that the intent of somebody just trying to stop somebody or kill them? That's an ace. Let me talk about Jason Levesque's claims that he made to Detective Gerson. Confusion, memory, tiredness. Look, these...
Getting your scrotum blown off probably isn't that fun.
Lies that he made that we talked about were central issues required for self-defense. He didn't just happen to, stumble upon some misstatements. These are not the misstatements of, I don't know, confusion, misstatements of fatigue, like his distance was off, fibs to cover for his pride or embarrassment. They are essential features to support a non-existing self-defense claim. If you had a bad memory, you were so confused or overwhelmed, you'd say to the officer, you know what, I don't remember that. I don't remember that moment. I'm confused about that moment. But he never said that. Instead, in response to Gerson's questions about, well, what happened after you took out the firearm? He gives a vivid, a pictorial account, a visceral account. He said, I took out the firearm. Did he stop? No. He continued to advance towards me. In fact, he hastened, his words, hastened his face towards me. It had been 10 feet away, but then he rushed. And I could see in his eyes his aggression. All of it, complete fabrication and nonsense, but all of it essential for a self-defense claim. So what did you do? I fired. Stay on his feet? Yeah. That's not confusion. Confusion, I don't know what happened. He gives a very precise answer. Why? To justify the next 5 shots. Did he go down? No. He didn't appear to flinch. Maybe he flinched because of the noise. But I don't know if I even hit him. Because he kept coming at me. Well, then what happened? That's why I had to unload those next 5 rounds. That's not confusion. That's not, I'm not sure what he was doing. He's coming at me. And he gives this vivid, nonsensical. The degree of mendacity is breathtaking. He literally says, I shoot him 5 times, and he holds his abdomen and turns away and walks back to his home. That's a self-serving lie to fabricate self-defense because he knows what he did. Otherwise, we'd see kind of this random confusion of facts that some support, some don't make sense, some aren't corroborated. But it just happens to be that each lie is such a divorced distance from truth and happens to land squarely within a set of facts that would support self-defense if true. But we got some aces. We got videos that demonstrably show he's lying. Let me talk about some other aspects of the defense claims. That he was tired at the street side and therefore was having difficulty. We've got to adopt this 40 hours of sleep. First of all, that whole notion that he was up for 40 hours is a credibility question for Jason Levesque. He's working for a commercial plow company that has some liability. You think they don't give them breaks over the course of the day, that they're not conscious about the amount of time somebody's on the road. He's operating a commercial plow where apparently even at that hour he's able to make precise judgments and assessments of distance, of force, to plow, to pick up his daughter, drive safely there, but he's too tired in the next 5 minutes to make rational assessments about risk and whether or not the defendant, Kyle, is on his feet or not after getting shot in the head. Let me just say, he's not tired in the sense that that he's absolved of responsibility. He may be sleep deprived and dangerous, but that's a different matter. How about that he consented to the videos? Look, he's sitting there in the, this is another immunity card from the defense. Well, he gave him the video.
Did I miss the start of In Chinaland? I know there's a movie called Chinatown, but I never watched it.
Look, Garston...
I did watch Showdown in Little Tokyo, and I did watch... what's it? The Kurt Russell one about Chinatown. Big Trouble in Little China. Great movie.
Heard about the video.
Oh, F1. Yeah. Bierman qual 12 for for the sprint the sprint will be 11 your time tonight. I won't see it. I will be sleeping. And Hamilton took pole.
Earlier on, he looked back at page 66. He hears about it at page 27, but he's the one who says, hey, you got video from tonight? And it's true.
I didn't say he sucked. I said he hit the wall last week. You're like a woman. You only hear what you think I say.
The defendant signed over the video.
I don't know. They are legally probably obliged to do it, but I know people who work for plowing companies, and they'll have their normal work and they'll go out plowing at night. So it might be a good story, but it might not be true.
Do we know whether he's thinking, hey, maybe there's a Hail Mary here, that there is a kind of a perfect convergence of omission? It was pretty close. I mean, one of the videos just has him coming into view. The porch video is facing down. The garage video has only the sliver. And do we know whether he's making that calculation or not? I don't know. But we know he couldn't count on 43, pulling it all together, getting that arc of a view, that if you see these things in conjunction, you know that Kyle Violette stopped when the gun came out. You know, with the totality of these videos, that he was closing the distance. You know that there was sufficient time between brandishing the firearm, Kyle stopping, and pulling the trigger to assess risk. You know he went down after the first shot, and you know he came over to try and execute him with the next 5. That he gave them that video doesn't change any of that. Those are 4 aces. I hope he doesn't do anything stupid.
No, but again, you can't use it as a defense that you were sleep deprived, because it's upon you to take your breaks and sleep. I have a lorry truck driving license, and there's specific rules I have to follow if I drive a truck, unless I rent a truck and drive it privately. But if I worked, when I used to work for a furniture company, and you have to have X amount of breaks, but we have this tattletale in the cockpit, the dashboard, that will tell you how many breaks. So every time I jumped out and moved furnitures and was still working, it counted as I was on a break. So my driving time, because I wasn't driving, so I was clear on that one. But it was incumbent upon me to make sure that I at every time was clear-headed enough to drive the vehicle. And you can't say, well, I was drunk as hell, so I might have done something wrong, but I was drunk. Come on now. That's willful intoxication. It's the same if you sleep deprive yourself. It's willful intoxication. You can't claim it as a defense. No one forced you to stay up for 40 hours.
Stupid. Look, you want to talk about red herrings? Let's assume that she was talking about Kyle. Stupid doesn't mean that he's going out there. What she doesn't say is, boy, he's armed and dangerous. I hope he doesn't go out there and kill him. Stupid is going up and putting your nose in somebody's face and making a horrible threat that could have resulted in him brandishing a firearm or getting punched in the nose. But nothing about, geez, I think he's going to go out there and kill him. Red herring.
In Denmark, the owner of the truck will get twice the fine you'll get if you break. It's called dry break time. No, that's not a euphemism. Yeah, but don't they carry some liability anyway as the company? I don't know.
Let's talk about this repeated mantra claim from the defense that Kyle Violette is a lunatic, a maniac. Look, maniacs run out into the road with a bloody axe and threaten you. Here, let's not forget the actual facts here. And they want to omit, the prior event with the snow to make him look like a maniac. You heard from Kyle's daughter. That's got to be one of the most objectively grounded, reasonable, pleasant witnesses we've seen. And she described being at home with her dad, who she adores, and planning a family night. Sitting down at dinner, watching a movie.
Yeah, but following the law, he should have been doing that. So if he chose not to, then again, he can't use it as an excuse. I think that's what he was saying.
Everyone went to their room, and they were getting apprehensive about the plow not showing up, and that they were all going to have to get out there and shovel, and the anxieties went up. And even Kira, Jason's daughter, acknowledged that, the first storm, we did plow in front of his place, and they did say something. We said, it'll melt. And so there was anxiety about that. I'm not suggesting, again, that the threat is reasonable. I'm suggesting it's not maniacal, that there is context for this, that there's history for it. Don't put that in front of my driveway again. It sort of diminishes the maniac view of this, doesn't it? And likewise, let's go through just some of these other efforts to...
He was in the car when Kyle came out. I'm not sure I'm understanding.
Assail Kyle's sort of humanity.
In Denmark, our Teamsters have a big say in the rules, yes.
The so-called prior event, what was that about? Talk about innuendo. I mean, we had, once we got into the detail of it, it's like, well, who is this guy? I don't even know if he was my neighbor. I couldn't pick him out of a lineup. Did you call the police on Kyle? No. Did you see Kyle again before this? He might have been taken out of his trash. He can't even identify that dude. And they're bringing that forward as some sort of an assault on his character to create an image in your mind that is much different than the guy who was having a family dinner and got anxious about having a hand remove snow. That's not fair.
Oh, he was pressure washing his house. I thought I heard car at one time, but when I rewatched, he was pressure washing his. Oh, so the first time he came out and said, "I'm gonna unalive you." Okay.
What about the claim that when Jason returned to his vehicle, that he told a joke about running? That is more breathtaking mendacity. Somebody who just shot somebody this side of death can't possibly tell that kind of a joke unless they're a sociopath. And you know what? He has to recast it again, very much aware of the self-defense claim. If he got out there and admitted, yeah, I was thinking of running, it's an admission that he knew what he did violated the law. Because only people who violate the law and want to avoid legal recourse and consequences run. The first thing he says to his daughter is, should I run? And this isn't just a passing, moment. You heard what Kira had told the police. He asked me, should I run? I said, no, can't run. And he doesn't stop it there as a ha-ha joke. He says, well, then what should I do? Her response is not, oh, ha-ha, you're joking. It's, this is your path. You've got to figure this out. Should I call 911? I don't know. And no, he doesn't. That's not a joke. That's an admission of a guilty state of mind immediately after these events went down. I'm in trouble. Not because he came at me after I brandished the gun. Not because he continued to come after me after I shot him in the head. Not because he continued to be a threat lying on the ground, bleeding to death from a dissected carotid artery. Because he was in trouble. He wasn't justified in shooting him, and he knew it. And that brings us to the police station where he contrives these litany of self-serving lies. We had heard in opening that, if Kyle wanted to kill him, he could have. He could have gone back and got another magazine. These images depict Kyle's intent. Excuse me, Jason Levesque's intent. Kyle Violette was as close to dead as you can get without a funeral. This is the intent to kill. There was no discretion on the part of the defendant to temper his use of violence.
Yes, he walked into Jason's property, got all the way up in his face, then walked back, and then the discrepancy starts. Jason says he turned around, that's when he pewed him the first time, and then he came at him. But the video shows that he pewed him in the face, then he fell down, and then he walked up and pewed him in the back. I believe it says own truck. Yeah, it's kind of hard to follow along when they keep doing this.
Weigh the reasonableness, the degree of that violence in light of the actual evidence. Take a look at it. I want to talk briefly then about this notion of Kyle's actions that create then a reasonable belief. He's on the ground in one instance and stopped in the next. And now you've been invited to view Jason's perception of that and to simply accept that whole plot. That's not the standard. Jason needed to have believed he was in imminent.
Again, I don't know if they're done for today. We're going to switch over to the live feed after, but about 5 hours yesterday.
Threat of receiving deadly force. We know he wasn't because he was in control of the firearm. We know he wasn't.
But I think the thing is, we are always sitting here, and I have my opinions, you have your opinions. Danny T says, I'm slow. And then we talk it all the time. The jury is sitting there for 8 hours, well, not in this court, 5 hours a day, and then goes home. And then they start discussing the facts. So we're probably ready to pull the trigger way before they are. Thank you, Brandon. Don't pull Brandon's chats up before you read them, even if it's a super chat, because Brandon, it's Friday and he's in a mood today. Good morning, Kim.
Because Kyle stopped. We know he wasn't because Kyle was crawling for his life when he received the next 5 rounds. But even, so that's the first prong. Even if you get there, you do get to evaluate this objectively to determine whether it's reasonable. And to dismiss it simply because he was tired is not the law. If he was tired, he should have used extra caution and care with a firearm and the actual use of deadly force. Being fatigued is not an immunity card. It doesn't dispense with objective notions of reasonableness. We literally heard from Jason Levesque
That's what he claims.
on the stand that, you know what, I don't even know what self-defense is. You lawyers getting tricky on me with this defense notion, self-defense. I didn't know what it was, therefore I couldn't have been contriving it. Here's a guy who explained that he carries a weapon because of a prior incident with some machete.
But again, remember, I've also cut a lot of time to talk about the Karen Reed case today. If anyone follows Betterow on Twitter, he's really angry.
Of course he knows what self-defense is. He literally explained that's why he carried. And yet we're supposed to believe he's too confused, too ill-informed, too tired to reasonably weigh out self-defense. He knew self-defense and that's why he lied. He knew self-defense, that's why he carried and he was supposed to carry responsibly. Look, ladies and gentlemen, I want to sort of address and end on this issue, another concept that we heard in opening statements. At one point, Attorney Sisti said, basically, this is the theory of the case. Kyle Violette got what he deserved. You know, first of all, to assess that, you got to take a look again at what Kyle got. And it's in these pictures. This is what Kyle got. And it was all from words. Grossly inappropriate words, but words nonetheless, not married to, not advanced by actual threats. And it is, you know, at this point that we invoke justice. That, I told you at the outset, it sounds kind of corny, and if I said this around my Thanksgiving table, I'd be asked to leave, but embedded in our civic duty, our civic culture, justice is sacred. The process of achieving justice is embedded, provided for in our Constitution, the process of determining justice. And it doesn't require that you abandon, as you've been invited to, scrutiny of Jason's actions, that the frame-by-frame viewing of whether he stopped or not is unfair. Because that's exactly what we do. We don't, get shamed away from judging these kinds of actions. What we do to achieve justice is, in fact, invoke this process. The prosecution has a burden to come in and present evidence to a group of citizens, jurors, who take an oath. This process makes our system of achieving justice probably the best in the world. Not perfect, but probably the best in the world. You evaluate that evidence in light of our burden, but using your individual and collective common sense and apply the law. You do that in this case. The path to justice is, in fact, guilty verdicts on both indictments. And I ask you to endeavor on that path. Thank you.
Thank you, Counsel. All right, so ladies and gentlemen, as you can see, we've now reached the 12 o'clock hour. It's been a long stretch of sitting. So I'm going to take this opportunity for the lunch break. So we'll take the 1 hour lunch break. We're going to come back here. At that time, I will instruct you on the law. That takes a little bit of time. It takes about 20 minutes or so for you to do that. And once I've done instructing you on the law, then we will have the
Jury is still deliberating and has been for 3 hours today, so they are up to 8 hours of deliberation on this case. I don't know if I would have done this long. Do you agree our system is the best, Baker? I have my personal opinions about what I like and I dislike about the American system. I think it's sadly become a system for lawyers more than for the people who are being charged in it. And it's also a system where money buys its way, which it shouldn't do, where you have plea agreements that, in my opinion, isn't justice, because they can just charge you, and if you can't fight it, and if you go destitute, you'll take a plea. So I don't like that. Is ours better? A lot of people will probably say that we are too lenient on the punishment. We had a guy today who got 2.7 years for attempted unaliving, which is in some people's eyes laughable. I think every country have their system, and every country believes that there's a lot of merit to the system they have chosen. I think the American system is way, way, way too overrun with lawyers. And because you have so many lawyers, you make an impossible system, because it's so highly, I don't know if I want to say contested or what word I want to. There's so much waste in your system because someone at some point won a lawsuit, so now everyone else have to fight against that. Absolutely ridiculous amounts of time are being wasted on opening and closing arguments, which is in nowhere necessary. If you just put on a case, you don't need those opening and closing arguments. I think stuff like jury instructions are way too complicated. No normal person who doesn't understand law has any understanding of what happens. So I think the American system is probably good. The Danish system is good. The Australian system is good. Every country have their benefits and their downsides. I just think that biggest problem, and again, based on what I have been seeing for so long, is you bring politics into your courtrooms by having elected judges and DAs, which mean I want to win re-election, I'm going to get you. No matter if I have to put your lawyers on the witness list and F up your 4th and 6th and 14th Amendment rights, I don't care. I'm going to get re-elected. You waste way too much time because everyone wants to talk. Lawyers love talking, and lawyers are really bad at talking because lawyers talk to lawyers. Lawyers forget they need to talk to jurors. I've said this a million times. No one understands half the things that's being said because they go through all of these long speeches with $5 words. Most of us are stupid. Most of us can barely understand $1 words. It's a big problem that 12 members of the society of your peers have to decide, and they don't understand what is being told to them because lawyers F it up. So I think that's a big problem in your system. I can talk about problems in our system as well, but I was asked if I thought you had the best system. I really don't. I really think that you have too many lawyers, and they forgot what they're there for. They are there to find justice, and they are there to protect their clients. And I don't see that when I see most trials. I see vindictiveness from prosecution. I see shadiness from defense. It's very long between the good cases where both sides are good. The expert has a law degree. He can hop on and explain it for us in a matter of 2 pixie sticks. He gave up pixie sticks. Then we can't do it. Yeah, and that's a big problem in my opinion because they waste way too much time. Only people who love to talk as much as lawyers are politicians. Maybe that's why so many lawyers become politicians. Lawyers do not understand how to speak to a jury here in the US. It's more about winning and not about truth and justice. Yeah. That's not the system per se. It's just corruption of the system that could fix it if they wanted. Then it is the system. Because as we say about Massachusetts, that's how the system is today. On the basis of it, if you go back to the good olden days, it was probably one of the best systems with the most rights in the world. But then lawyers came, and lawyers need to get a paycheck. And how do lawyers get a paycheck? By inventing problems for other people. And I think that's a really, really big problem in the American system is that there's so much lawyerness going on because closing arguments shouldn't be 45 minutes. Not closing arguments. Jury instructions shouldn't be 45 minutes. Jury instructions should be, first of all, this is the law. I read the law. If I want to find out what this case is about and the potential punishment he can get, I just go put in Massachusetts attempted unaliving. I'll get, this is the law. That's what the jury needs to know. Did they prove these elements are enough to break the law? I also hate your lesser includeds, by the way. And they shouldn't be sitting in there, and if by any means you have speculated, then you should unspeculate before you then speculate, and remember that speculation is also a way of speculating, but you are allowed to speculate if the speculation didn't occur before the 5th in a month where there are 2 Thursdays on a Wednesday. Why? Just read them. What is manslaughter? What is an OUI? What is attempt? Tell them what the legal definition of that is. You don't have to say the rest. And then you say any reasonable doubt must benefit the defendant. It doesn't mean every doubt, it's every reasonable doubt. So you don't have to sit there and say, well, he could have been somewhere else, even though he said he was there. But could it have been reasonable for him to do what he did? Or is it reasonable to doubt that it happened the way the defense says it, state says it happened? Instead, you're getting 45 definitions on one word. And I believe you are confusing the jury, and that's why you have so many bad rulings, because the jury don't know what's going on. Because it's lawyer talk, it's not jury talk. You should actually have a committee that went in and dumbed everything down. Say, we don't have, well, we had an appeal on this and this and no. The only thing the jury instructions will say is, this is the burden of proof. And this is the statute that they have been charged with. All the lesser included won't be allowed, because if you're going for murder one, you better prove murder one. Yeah, but manslaughter is so far below murder one, it should never ever be allowed. Then you must make your your manslaughter case. But the problem is, it's just bingo, bingo, bingo. We're just going to put everything on the plate. The idea of due process is uniquely American and indescribably difficult to explain, and that's why it doesn't exist. If you can't explain it, you can't defend it. No, it's not perfect, but yeah. We don't have a queen, we have a king now, Brandon. Follow along. Lesser included raised out for me. Yeah, if you need a lesser included, then you have to charge down. You can't come in here and say, well, I want everything from murder to murder two, to manslaughter, to attempted manslaughter, to jaywalking. Then you should only be allowed to argue the lowest charge you bring, because if you don't believe you can prove the first thing, well, fuck off. In Denmark, if we, for instance, have qualified violence or excessive violence, we can determine that after listening to the testimony, we believe that there was violence, but it wasn't excessive. So it's just, instead of 245, it's 244. We can make that determination and say, well, it's a lesser included, which isn't included and isn't argued. But it's just, we can make that determination and say, okay, it's not enough, but he did punch him in the face. But it wasn't enough that it's aggravated assault. So we're just going with assault. We do that determination. I just want a bicycle clown. How the hell do you make a bicycle clown? I don't know what this is, but it's a bicycle and a mutant. That was the closest I could get to a bicycle clown. Lesser included is part of the winning thing. If we can't get the conviction with one charge, we'll get it with another. Yeah, and that's the problem, because they're not there to win. They're there to find justice. This DA was an example of why people like me would consider jury nullification. Yeah. Baker is not a queen, let's go, Brandon. He is more of a prince like Kim Jong III. Or Kim Jong-il. Lefty. Lawyer are here to make fart jokes on YouTube. Well, that's a lawyer who... How many jurors are on your jury? Where I am, where the minimum sentence we can give is, I believe, a month, and the maximum is 6 years. We are one judge and 2 laymen who discuss the case. Then you can go to the next level where you will have 3 judges and 6 laymen. I don't think we have 12-man juries, but that's the next step up. I am not. I don't want to go there because that's all the appeal stuff, and appeals are boring because it's just reading what was said in the lower court. I know you like him. Won't happen. But nothing's really happening with this one. So I think I'm going to jump off, make myself some dinner. And if they come back with a verdict, I might be fast and get on, or because I have to go to Baby Baker's tomorrow. So I'm also trying to get to bed at a reasonable hour tonight. And I need to read up on all the messages that is flooding into my Discord right now, because a lot of reading can be done. But I'm going to make myself some dinner. I might jump on there again. But before I go, Brandon, you ready? I'm going to send a link to Valhalla. He's probably out in the barn. But if you want to join us, it's Friday. It's Friday, Friday, Friday. Ooh, it's Friday, 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 yeah. And Friday means 1 beer at one time. I'm gonna go get my beer.
Let's get started. Oh, that's real good.
Ain't nobody stopping me.
When you get to Valhalla, click the pinned message. I don't know. Have a nice weekend, everyone. Oh, and by the way, no Stab Your Day tomorrow. But Sunday, we will be joined, Valhalla and I, by Defense Diaries podcast. So, oh my. Sunday, it'll be at 3 p.m. Eastern, where Bob and most likely Ali will both be joining us, talking about all the craziness that's going on in the Karen Reed case, because you can say a lot, but crazy is what it's getting. So 3 p.m. Eastern this Sunday, which will be 8 o'clock for you, Helen, and 7 o'clock in England. I love Ellie. She's like me, so mean and angry. Thank you, Marissa, for setting up Defense Diary podcast as guest for this weekend. Everything's easier when I don't have to do any work. Valhalla is, as always, sleeping, so Brandon, cheers, and go listen to Rebecca Black. I started becoming a layman because my mom had been it for years. Yes. Everyone's... The only cutoffs are you have to be 18, and back in the day it was 70 years old, but I think they moved it to 75 or 80 unless you get mentally confused, then you'll be dropped. I think that's it we have to do for today. Remember tonight at 9 p.m. Eastern, the only Friday night show that you need to watch is Friday Night Live. If I get out of bed, and I am most likely not going to do it, I will try and join. I woke up 17 minutes after it ended last week, but I have Baby Baker tomorrow, so it depends on if I get... I would like to have 6 hours of sleep before I get up. But you should go and watch it, because what else should you do? It's Friday. It's not like you're hanging out in the clubs like Irish, meeting all the hunky men and doing the dirty moves. So, go check him out tonight. And come back on Sunday. See you later.
What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100.
100.
Because it is 100%
100%.
correct.
So you literally built a cannon?
Yeah, it's pretty awesome.
All right, I'm in love.
Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No,
Did you believe he had slept with your wife?
no.
Did you believe he slept with your mother-in-law?
Probably did. Everybody has.
So there-
Everybody has.